Barge work is some of the most dangerous maritime work in America. Massive vessels, heavy cargo, powerful currents, and tight maneuvering in busy waterways. When something goes wrong, people get seriously hurt. But if you're injured working on or around barges, your employer probably won't tell you about the special legal rights you have under federal maritime law. They'd rather you think workers' comp is your only option. I'm maritime injury attorney Matt Schaefer, and in this video, I'm going to reveal 5 things your employer won't tell you about barge accident injuries, because understanding these secrets could be worth hundreds of thousands or even millions of dollars if you're ever injured. Under the Jones Act, your employer might tell you that you're just a regular dock worker or equipment operator. They'll act like workers' compensation is your only option when you're injured. But most barge workers actually qualify as seamen under the Jones Act. And Jones Act seamen have much more valuable legal rights than workers' comp provides. To be a seaman, you need to contribute to the function of a vessel in navigation and have a substantial connection to that vessel. Barge workers typically meet both tests. You're either working on the barge itself, or you're working on the tugboat that pushes or pulls the barge, or doing work that directly supports the barge operations. If you spend a significant portion of your work time on barges or vessels that handle barges, you're probably a seaman. That means you can sue your employer for negligence under much more favorable legal standards than regular workers' comp. I've successfully argued seaman status for deckhands who work on barges, workers who load and unload cargo on barges, tugboat crews that push barge tows, mechanics who maintain barge equipment while the barge is in navigation, supervisors who oversee barge operations from the vessel. Under maritime law, unseaworthiness is a legal concept that's separate from negligence. A vessel is unseaworthy if it's not fit for its intended use. You don't have to prove who was careless, just that the barge or its equipment was defective or inappropriate for the condition. Barges are especially prone to unseaworthiness claims because they have poor deck conditions. Barges often have uneven decking, missing handholds, inadequate lighting, and poor drainage. If you slip and fall because the deck surface is dangerous, that's unseaworthiness. Cranes, winches, and loading equipment on barges frequently break down or malfunction. If defective equipment causes your injury, that's unseaworthiness. If cargo isn't properly secured and shifts during transport, injuring workers, that's unseaworthiness. Barges take a beating. Worn cables, damaged cleats, broken railings, any structural defect that contributes to an injury can support an unseaworthiness claim. The beauty of an unseaworthiness claim is that it's strict liability. You don't have to prove the company even knew about the problem or should have fixed it. You just have to prove that the barge wasn't fit for safe use. Most injured workers think they have one claim, either workers' comp or a lawsuit. But barge workers often have multiple claims that can stack on top of each other. If your employer was careless in any way that contributed to your injury, you have a Jones Act negligence claim. If the barge or its equipment was defective or unsafe, you have an unseaworthiness claim. You have a maintenance and cure claim for living expenses and medical bills that your employer owes you regardless of fault. And if your injury was caused by equipment made by another company or negligence by a different company working on the same project, you have a third-party claim. I handled a case where a barge worker was injured by a defective crane. We filed a Jones Act claim against his employer for inadequate maintenance, an unseaworthiness claim for the defective crane, and a products liability claim against the crane manufacturer, a negligence claim against the company that was supposed to inspect the crane, and each claim was worth hundreds of thousands of dollars. Together, the case settled for $3.2 million. Barge operations typically involve multiple companies. The company that owns the barge, the company that owns the tugboat, the company that owns the cargo, stevedoring companies that load and unload cargo, equipment rental companies, maintenance and repair companies. When you're injured, your direct employer might not be the only company responsible. Other companies involved in the operation might also be liable for your injuries. This is important because it can dramatically increase the amount of money available to compensate you. Instead of suing one company with limited insurance, you might be able to sue multiple companies with multiple insurance policies. Your employer won't investigate the other potential defendants. They're hoping you'll settle with them alone for much less than your case is worth. For most workers' comp claims, you have a year or two to file your claim. Your employer will use the short deadline to pressure you into accepting a quick settlement. But Jones Act claims have a 3-year statute of limitations. You have 3 years from the date of your injury to file a lawsuit. This extra time is crucial because it allows you to fully understand the extent of your injuries before settling. It gives you time to investigate all the companies and factors that contributed to your accident. It lets you find and hire an experienced maritime lawyer who can properly evaluate your case. Your employer doesn't want you to know about this extra time. They want you to feel rushed into accepting their first offer. Why do these secrets matter? Let me give you a real example of how these secrets can change the value of a case. I represented a barge worker who was injured when he fell through an open hatch cover. Initially, everyone treated it as a simple workers' comp case. He would get his medical bills paid and maybe $100,000 in disability benefits. But we investigated and we discovered the worker was a seaman under the Jones Act because he spent 9% of his time working on barges. The barge was unseaworthy because the hatch cover was missing safety railings required by the Coast Guard regulations. His employer was negligent because they knew about the missing railings but chose not to install them to save money. A third company that had modified the barge was also liable because they removed the original railings and never replaced them. Instead of $100,000 in workers' comp, this became a $2.1 million Jones Act settlement. Your employer is probably hiding red flags. They immediately start the workers' comp process without mentioning other options. They tell you that maritime law doesn't apply because you work close to shore or on inland waterways. They pressure you to accept the settlement quickly, claiming the offer won't be available later. They discourage you from hiring a lawyer, saying they'll take care of everything. They claim the accident was your fault and try to get you to admit fault in writing. They offer you a lump sum that sounds generous, but doesn't account for all of your damages. So what should you do if you're injured on a barge? Report the injury immediately and get medical attention. Document the accident scene if it's safe to do so. Take photos of the barge, the equipment involved, and any dangerous conditions. Don't sign anything beyond basic incident reports until you understand your rights. Don't give recorded statements to insurance adjusters. Don't accept any settlement offers until you've had time to investigate all your legal options. Talk to a lawyer who specializes in maritime law before making any decisions. Barge accident injuries are often worth significantly more than workers' compensation benefits, but only if you understand your rights under maritime law. Your employer isn't going to explain these things to you. They benefit when injured workers don't know about the Jones Act, unseaworthiness claims, or the complex liability issues involved in barge operations. Don't let their silence cost you millions of dollars. If you've been injured working on or around barges, you need to understand whether you qualify as a seaman under the Jones Act. Watch my video explaining what the Jones Act is and how it works. And if you want to know whether these maritime law principles apply to your specific situation, there's a link in the description for a free consultation. We handle these cases nationwide. We only get paid if you win, and we'll give you an honest assessment of your rights under the maritime law. Barge work is dangerous. When that danger results in injury, you deserve full compensation under the law. Don't let your employer's secrets keep you from getting what you're entitled to.